Boongaling versus Banco San Juan GR Num 2, 14259, November 29, 2022. Boongaling and Diate were depositors of Banco San Juan, and their passbook reflected a balance of P574, 313.93 as of December 9, 2008, and claimed that they never withdrew money from the account after said date. Later, they received a letter from the bank informing them that their account has become dormant and requesting that they activate their account. So they went to Banco San Juan's Baguio City branch to activate their account, but learned that their account only contained P16,000,00 instead of P574, 313.93. Upon investigation, they learned that two former employees of the bank had stolen money from the bank by forging the signatures of its depositors. Thus, they filed a collection of sum of money against Banco San Juan and alleged that it was caused by the two employees who forged their signatures. The bank denied the allegations and countered that the signatures were genuine, and considering their withdrawals plus the dormant fee charges, the remaining balance is now only P15, 807.49. Diate and Boongaling moved for a judgment on the pleadings on the ground that the bank's answer failed to tender an issue and contained mere denials. The RTC granted the motion and ordered the bank to pay plaintiffs, Boongaling, a total of P1, 674,313.93 in damages. The Court of Appeals reversed the decision of the RTC and ruled that judgment on the pleadings is incorrect and that the answer tendered an issue. Whether the CA was correct in finding that the judgment on the pleadings was incorrect. Ruling yes. The Supreme Court ruled that the bank's answer tendered several issues, namely whether Boongaling's and Diate's signatures were forged by the bank's former employees to facilitate two unauthorized withdrawals in the amount of P580,000 from their account, and whether the bank was negligent in the handling of their deposit. The Supreme Court defined judgment on the pleadings under Section 1, Rule 34 of the Rules of Civil Procedure. It ruled that an answer would fail to tender an issue if it does not deny the material allegations in the complaint or admits said material allegations of the adverse party's pleadings by confessing the truthfulness thereof and/or omitting to deal with them at all.
In this case, while the bank admitted that Boongaling and Diate had an account with them and that two former employees made several unauthorized withdrawals in some of the bank's accounts, it categorically denied that Boongaling and Diate's account was affected by the same, and further denied that the two withdrawals in their account amounting to 580,000 pesos were unauthorized or covered by forged deposit slips. Moreover, respondent clearly contests the opposing party's version of facts and avers that as far as bank records are concerned, the withdrawal slips used to withdraw from the bank, and the signatures of Boongaling and Diate therein are genuine, and their remaining balance is 15,807.49. In view of the issues raised by the bank regarding the allegations of forgery and negligence, the trial court erred in rendering judgment solely on the basis of the pleadings and its attachments.